I'm Drew Stevenson. This is a video for my administrative law class. And here we're going to be talking about Crusader Gun Group, LLC versus James. This is a Fifth Circuit Court of Appeals case from 2024 about license denials and modern due process hearings. Let's dive in. Just to give a quick overview, what's going on in this case, ATF denied an application for a federal firearms dealer license, or FFL, because the person who submitted it, the application had a history of a lot of egregious violations under previous dealer licenses that he had held in the name of some shell corporations. He appealed based on a statutory argument and due process hearing rights, and we're going to talk briefly about both of those. Why are we talking about it? Well, the case is actually a really good illustration of how modern courts approach due process issues for agency hearings. In our course, we read a lot of the landmark decisions about due process, like Goldberg v. Kelly and Matthews v. Eldridge, but a lot of them are cases from the 70s and the 80s. And in the decades since then, even though those old cases are still good law, the law has sort of matured and settled so that the courts will move through a checklist for due process rather quickly. And this case is a nice example of that. Also, licensing and permitting regimes are a big part of regulatory law and practice, including denials and of those. And the case illustrates how the denial works and how you appeal it and so forth. And at the same time, the very small amount of discretion agency officials actually have under their enabling statute in granting or denying these licenses. Okay, I'm going to give you just enough legal background to understand what's going on in this case. Federal firearms dealer license applications, or FFLs, are often submitted by a gun store, or like a corp that is incorporated or is an LLC. So it's a legal entity, but the application requires that entity to identify the, quote, responsible person. And by that, we mean an actual living, breathing adult human being. Now, the entity, like an LLC, is technically a legal person for purposes of other laws. So it can be sued in court, it can file lawsuits, it can make valid contracts, and so forth. But for this, we need to know who is the person behind this. Now, the federal statute tasks ATF with processing and applications and overseeing gun dealer licensing regime, basically, and doing inspections and audits of gun stores and so forth. And identifying a human being behind an entity is commonplace across administrative law. So lots of state and federal government application forms for permits and licenses and business registration and special tax exemptions and so forth require that there be some human being with a street address and a social security number who is identified on the form. Now, make clear for my students, this is not a Second Amendment case. There are other courts currently considering Second Amendment and challenges or other legal challenges to some of these same dealer licensing rules around the country, but not this case. It doesn't really involve such a challenge. And in fact, the Fifth Circuit points out that at the time of the dealer's violations, the person in this case, the requirements in question were good law under Supreme Court jurisprudence. So not every gun case or gun-related case is a Second Amendment case, according to the courts. So let's meet the parties. In the case of Crusader Gun Group LLC, Alan Ehrenstein had identified himself as the responsible person and president of the company. And so when ATF got this application, someone did a routine cross-check for Ehrenstein's name in its records or database. And the cross-check revealed that he had also been the responsible person for 3 previous entities that were now defunct that had firearms licenses. And it also turned out that with these previous businesses, Ehrenstein had, and I'm quoting the opinion here, more than 6,000 record-keeping violations, failure to report the theft or loss of more than 200 firearms, failure to put serial numbers or serialize 2,400 firearm frames, and the possession of unlawful machine guns. Why do we talk about this? Well, the court probably cites these specific numbers to emphasize that these are not merely a few harmless clerical errors or isolated instances. Instead, this is a repeated pattern of a dealer who just simply ignores the law and the clear rules that honestly most law-abiding gun dealers would follow these rules, but Ernstine did not. And in fact, his violations have been serious enough that back in 2021, ATF had informed Ernstine that it had been looking into one of his three entities and it was planning to revoke the license for that entity. Well, he realized he was under investigation, so he basically surrendered or forfeited all of his three existing dealer licenses he held for different shell corporations, let's say, and at the same time created a new LLC, which is Crusader Gun Group, and applied for a gun license for that entity, which would have been his fourth. So ATF denied his application and then gave him a hearing to review its adverse decision or to contest it and ask for reconsideration. This is very common in federal administrative law, that if you have a license or permit application denied, or you had a license and it gets revoked, that you're going to get a hearing. And at the hearing, ATF presented their side of the story. They put on evidence to support their decision. They called witnesses from the agency who explained how they do things and why, and so forth. The hearing officer who presided is one of the people pictured here. Ernstine himself had a lawyer at the hearing, but he and his lawyer didn't present any evidence really supporting his side of the case. They just cross-examined ATF's witnesses. And you may be saying, well, what kind of evidence could he have presented? Well, maybe he could have said, I'm a changed person. I know I blew it in the past, but I want to turn over a new leaf. Give me another chance. And here's a bunch of people that will vouch for me that I'm a changed man. Or he could have said, I had a business partner who went rogue and committed all those violations with those other three entities, but now I'm operating alone and not associated with that person, so you can trust me. He could have made a number of arguments that he didn't. And so he lost at his hearing and asked for judicial review. And so that's how we end up in federal district court. And the first issue is a statutory issue. Did ATF have legal authorization from Congress, and what that means under its enabling statute, to deny FFL applications based on prior violations attributed to the responsible person rather than the entity that was applying for the license? In other words, Ernstine's argument was, look, Crusader Gun Group is a brand new LLC, and it never existed before. It hasn't done anything. It hasn't even been open for business yet. So it has no violations. And any of those other violations were other corporations. And ATF said, yeah, but it's the same guy running all of these small businesses. So what do we do in administrative law? We look at the statute itself and parse it to see if the agency complied with the statute or operated within its statute. And the statute here is 18 U.S.C. 923 D1. And you'll note that it doesn't give ATF much leeway or discretion in making these decisions. So it starts by saying ATF must or shall approve FFL applications. So the default rule is that they're going to grant all of them unless, and that's a big unless, one or more disqualifying factors is present, and then it specifically delineates what those factors are. The first two factors screen out people who are legally prohibited from buying or selling guns under other federal laws, like convicted felons or people who have been institutionalized in mental institutions, undocumented immigrants, people who have renounced their U.S. citizenship, and so forth. And the third one screens out applicants with prior willful violations of federal gun laws, even if they're still eligible to own a gun. The fourth screens out fraudulent applications where the application itself is the person's using an alias or a fake name or a fake address, a fake social security number, something like that. You get the idea. And then there's a couple more factors like these. But the third factor, which is prior violations by the applicant, was the only one at issue in this case. And Congress actually defined applicant elsewhere in the same statute as the individual possessing directly or indirectly the power to direct or cause the direction of the management and policies of the entity. So Ernstein and Crusader Gun Group are arguing that it's the entity is the applicant, not the responsible person. But if you look at the statutory definition, the court concluded pretty quickly that it's talking about the individual, and that means the responsible person. And that brings us to the due process challenge in the case, which is the other main basis for seeking judicial review. And due process is kind of a big umbrella concept. It's a little bit vague, but there's a lot of factors that go into it. And one of those factors is, who was the hearing officer conducting the hearing? The hearing officer cannot have a direct financial or personal stake in the specific case. Now, that said, courts consistently say it's fine and even customary for a hearing officer to be an employee of the agency itself. And so even though the agency is one of the parties in the hearing. And so it's really a rookie mistake for lawyers to go into a hearing and say, you can't be a hearing officer because in this case, because you get your paycheck from the other party in this hearing. The courts have long ago said that that was fine. And that's what happened in this case with Tanera James, who was ATF's Director of Industry Operations for the Houston Field Division, and hence she became the named individual defendant in this case. So let's talk about the court's holding. The court quickly concluded that the applicant had actually received plenty of due process, and ATF had indeed acted pursuant to the relevant statute. As courts often do in these cases, they mentioned a bunch of other procedural fairness protections that were afforded to Crusader Gun Group. And this is the most important slide in this video. You may want to pause it and take a good long look at this, because this is where they really get to the heart of the due process analysis. I pulled out a quote. The court mentions, quote, written notice of the reasons for the denial, a hearing to challenge the denial, copies of ATF's evidence in advance of the hearing, the opportunity to have legal representation and to present evidence and to cross-examine ATF's witnesses during the hearing. And last but not least, judicial review after the hearing of the hearing officer's decision and the hearing officer's conduct at the hearing. And so this is actually the part of the case that's why I'm covering it in my course, is that look at how quickly the court just kind of goes through like a checklist. And the fact is ATF had checked all these boxes. They gave written notice of why they were denying this. They put it in writing and sent it to the Crusader Gun Group. They gave them a hearing in advance of the hearing. They told them what evidence they were going to put on at the hearing, so there were no surprises or ambushes. He got to bring a lawyer to present evidence, but they didn't, or cross-examine witnesses, and they got judicial review. So we have all the process that he was due. Now let's connect this to some other areas, larger areas of administrative law. Licensing and permitting regimes are a pervasive feature of every modern society and legal system. So we have professional licenses for lawyers and doctors, driver's licenses, import-export licenses sometimes for specific products, and so on. And these are one of the main ways that modern legal systems protect consumers from, let's say, fraudsters and scammers, and also the workers, right? So there's people who sign up, let's say, especially college students or people like that who get rooked into working for a company for the summer, and they end up never getting paid, right? So the company closes up and disappears, and the person running it was a con artist who skips town and never pays the employees. And so licensing can create a way to, it's not perfect, but it can keep that in check. Also, we have a public sort of policy interest protecting the public from front organizations for criminal cartels and terrorist organizations. You may, if you watch the show Breaking Bad, one of the plot lines in that show is that this a drug dealer is laundering money through one of them through a nail salon, another through a car wash. So they have this, what looks like a legitimate business, but it's really just there to help launder money for a criminal organization and a criminal enterprise. And of course, that still occurs, but the communication that has to occur, the reporting and information sharing in a license or permit application can make it more difficult to hide from authorities or more likely that you're going to get caught. Let's talk about gun dealer licenses in particular. With gun dealer licenses, Congress did want to make it more difficult for criminals to arm themselves or even foreign adversaries. Remember, these laws were passed at the height of the Cold War era. There was a lot of concern about hostile foreign powers and terrorist organizations and so forth that might arm themselves or agents or other people who could pose a threat to public safety or national security. Now, a dealer license isn't going to completely stop that, but it can make it more difficult for people to avoid it, for bad actors to avoid detection. But wait, there's more. A licensing regime for gun dealers is also necessary to enforce federal taxes on firearm manufacturing and tariffs on imported guns. And so, if we're going to have a tax regime, we have to have a way of monitoring and making sure that people are actually paying the taxes. And a lot of times, licensing and permitting helps us figure out who the people are that are supposed to be paying taxes and whether they're keeping records and so forth. And the licensing regime for gun dealers enables a system, the gun tracing system for law enforcement to trace a gun that they recover from a crime scene, and the background check system we have for gun purchasers. And why am I going through all this? Because I want you to understand that licensing and permitting regimes might be a little bit annoying and tedious, but they can actually serve several policy goals at once. Not just they're not just there to achieve one purpose, but they actually might help with the enforcement and implementation of a number of laws and policies. One parting postscript here. In recent years, this particular court, the Fifth Circuit Court of Appeals, has been one of the most aggressive courts in the country for striking down federal laws related to firearms. And that makes it, I think, more noteworthy that this court so easily sided with ATF in this particular case, as did the Texas District Court. And that concludes our lecture about Crusader Gun Group versus James.